Good morning, everyone. First, by way of introduction, so my background is that I was at Freshfields, Brookhouse-Derry, just down the road for 8 years. And at the end of that time, I spent some secondment at the Olympics, London 2012, which was a fantastic experience. During that time at London 2012, I was privileged enough to draft some pretty sensitive contracts and some controversial contracts which involved some disputes, for instance, around the Olympic torch. It turns out that we couldn't make the torch, but no one knew that. We ended up in court trying to settle with the manufacturer and the designer, and there was lots of reputational issues surrounding a very symbolic part of the games that we couldn't make. In the end, we could. We made various compromises. And also drafted a contract for the Queen skydiving out of a helicopter with James Bond. If you may remember, that was a key part of the Olympics, and that was quite an unusual contract to be drafting. It wasn't signed by the Queen, needless to say. But during that time, I sort of was involved in various sort of board meetings where reputational matters surpassed those legal matters. So whether we could, whatever the contract said in terms of manufacturing the torch, it was kind of irrelevant. If we couldn't make it and people found out that we were looking into various options of it being made outside the UK, reputationally for the Olympic Committee, that would have been very, very damaging. Anyway, that was my sort of previous life. Now I work for Elderman, which is the world's leading, biggest communications firm. And I have their in-house role in London and deal with very sort of commercial, sort of up and down matters every day. But the most interesting part of my job is actually as a consultant for Elderman, helping clients through litigation and manage the reputational challenges that are involved during litigation. So I wanted to talk a bit about that, which is a bit more interesting than just some sort of up and down contracts. And first I wanted to start by sort of setting the scene, which is the changing legal landscape. And a lot of this is UK relevant, but also international as well. And the summary point is that we're in an ever litigious culture where everyone is suing everyone. And that's not going to change, really. It's only going to increase. So certainly from a UK perspective, English law abounds. 30% of the jurisdictions, there's about 320 jurisdictions in the world, 30% of them use English law as the foundation law for its surety and certainty and sort of impartial independent judiciary. And because of that, we see more and more legal tourists coming to London to resolve their disputes and litigation, whether you have pop stars or celebrity couples divorcing or oligarchs or international royal families. There's a sort of a migration towards London due to the reliance on the English law, meaning more and more litigation in the UK. And we've also seen some US influence. So traditionally in the UK, we've had no sort of ability to bring class actions. But now there's been a loosening of the class action laws, and some of Elderman's clients are involved in some pretty big class actions in the UK. So we've seen an increase in litigation through that means as well. And of course there's global trade. You know, this room is a rich sort of mix of multinational people and lawyers. And that's the same with businesses. Everyone's trading with everyone across borders, and that means cross-border disputes. And again, if it's English law governed, it means that dispute comes to London. We've also seen in the last couple of years an increase in litigation funders, where private equity firms with money go to a company which is very litigious and fund the most potentially successful litigation through court, which is an interesting concept. We're talking about facilitation fees, David, earlier, but to have someone funding your litigation, of course, means that litigation is likely to see its way through, when previously perhaps he wouldn't have had the money to take it to court. Obviously, there's lots of expense involved in litigation. So we've seen a rise in litigation through that means as well. Of course, I think this was talked about at the conference yesterday. There's a rise of arbitration and a loosening of laws around ADR. So there's more litigation through that means. And privacy is a privilege of the past. So you may have seen in the UK and the US actually that there was the celebrity threesome, which is the picture I've taken from the Sun's front page a few weeks ago, where quite bizarrely there's an injunction in place that's just been affirmed by the Supreme Court that doesn't allow the naming of the celebrity couple that were involved in the threesome, but in certain parts of the world, you can, if you're in Scotland, for instance, you can readily find the names of those individuals. If you're in England, you can't. So it just sort of exemplifies how the law isn't perhaps as powerful a tool as it was previously, because reputational matters outside the courtroom, outside the contract, have more of an influencing factor. And that's very much my learning over my 2 years at Elderman, that the underlying position, legal position, is less influential these days as various matters outside the court of law. So what do I mean by that? Well, we all know, it's very well established that if you're involved in litigation, you hire lawyers, and lawyers defend your legal position. As I say, what I've learned is that there are multiple battlefields today in today's sort of legal landscape, and law is just one constituent part. These multiple battlefields have various stakeholders who all have different agendas. And of course, you've got to convince the judge about your legal position. But more crucially, these days, you've got to convince the other audiences about your position as well. And if you don't work the multiple battlefields, then you will come up short. So some of those battlefields, obviously media is a huge battlefield, and more companies are employing use of the media to get across their point of view when they're involved in litigation. And that obviously started in America with O.J. Simpson 20 odd years ago, where media was quartered to position his case as best he could. But that was exceptional in those days, and it was sort of pioneering. Today, that is very, very common course. And if you aren't courting the media, if you aren't potentially briefing them, if you aren't having statements ready, if there's an announcement once the litigation's settled, or if there's a dispute that's just been commenced, don't have positions ready to say to the media, then the other side will, and they'll be on the front foot and you'll be on the back foot. And often parties resort to the media in litigation when they have the weaker legal position, because that's an easy way to get your point of view across. Another battlefield, and Dave and I were talking politicians earlier, is political. So one client we work for, the other side involved in litigation has been actively lobbying politicians and the Foreign Secretary. And one approach, you could say, is not to engage in that. But in this individual case, had we not engaged with that politician, it would have been very detrimental to our case. So you have to engage on the political side as well. There's what we call the commentariat, so it's the commentators, whether it be in the media or special interest groups who again portray various opinions and people believe them. So if you're not putting across your messages to that group, then it's to your detriment. And of course, there's your colleagues. So if there's an investigation launched or a governance issue, and investigators are in your offices, as the lawyer, you should be communicating with your CEO to your members of staff and clarifying your position as a company and making sure your staff know what the company's position is. And last but not least, around all those multiple battlefields are your customers and consumers. And they are influenced by all those factors. So if you're not fighting those multiple battlefields, obviously judiciary and legal being the foremost, but the other four as well, then the message doesn't get across to your ultimate consumers, and that ultimately has effect on your share price, because if they believe the other side, they will less likely to buy your product or to use your company for whatever your company does. And there's two quite neat examples in the UK that you may be aware of in recent times. So one was Thomas Cook, where there was a tragedy in a hotel in Corfu in about 2006, where 2 children died due to carbon monoxide poisoning. And obviously it's a tragic case, and it went to court. But from a legal perspective, fundamentally Thomas Cook were in a reasonably strong position, and their lawyers said we're in a strong position. Don't say anything, no comment, it wouldn't be appropriate, there's ongoing litigation. It turns out that that didn't go down well in the multiple battlefields, so the media was saying, why are you not commenting? We've as journalists tend to do, they've undug lots of background facts and are trying to pull apart Thomas Cook's case. Thomas Cook not commenting meant that the vacuum that was created by Thomas Cook not commenting was filled by other voices. So slowly over time, there was a picture built of Thomas Cook that it wasn't right, and in many cases it wasn't right. But the point being that in today's age, saying no comment isn't good enough, because that silence is filled by the other side. And you contrast that with Merlin Entertainment, which is the company that owns Alton Towers, the entertainment park in the Midlands, where again another tragedy happened, and a girl, there was a problem on one of the rides, and the girl lost a limb. Immediately, the chief executive, with his general counsel, went in front of the media and did an interview. Immediately on the front foot, apologising, not saying no comment, saying we'll do everything we can to resolve this situation, whatever it costs, we'll pay it. And immediately, just in that very sort of first hour of the incident happening, there was a positive reaction to what the corporate was doing, in stark contrast to what Thomas Cook was doing. And the legal position may have been similar. The point being that they were fighting other battlefields and getting their point of view across. And so an example of some of the media-savvy law firms out there at the moment and some of the tactics they're employing are sort of exemplified on this slide. And if you're not doing it during litigation, then you can be damn sure that the other side are doing this. So say it's a simple litigation case. Many firms, backed by litigation funders potentially, are identifying a case. They're crowdsourcing claimants. So they'll set up a website where it's very easily to, within a click, you can sign up and join the class action. And there's various promises that are made that are legally correct, but it convinces claimants this is worthwhile to fight my case. The law firms that will then have very favourable media contacts, whether it be editors or correspondents, and they'll be briefing those correspondents off the record, so when the story does break, their point of view is the one that's put across first. They will also create their own content. So we see on the right-hand side, there's videos on Facebook, there's Twitter accounts, there's dedicated websites. They will create that content and amplify it and spread it around, so people, again, are convinced their point of view. And all this may be in the context of them being in a very weak legal position, but you wouldn't know that if you read and see all the content they're creating. They'll employ third-party advocates, so they'll get someone famous. In one case, we had a film company, they were launching a film, and on the red carpet, they'd planted a third-party celebrity that highlighted the plight of the case against the company, and that obviously goes viral. And I think 5 years ago, the word viral, people would just dismiss it as social media and not to be concerned. It is hugely, hugely influential these days, and if you don't have your communications team working with your legal team, working with your compliance team, and it's all coordinated, if you're not doing that, then as soon as a crisis breaks, you can be damn sure that the cracks will start to open, and you'll be losing your positions. And often in all this content that's created by the firms, they'll be projecting a victim status. They'll be again, in contrast to the no comment response, which used to work sort of 5-10 years ago, they'll be putting claimants in front of media, in front of TV cameras, and projecting, woe is me, this is the issue, and it may not be factually correct, but it's often irrelevant. Once that's out there, you're on the back foot. So, in summary, what's sort of happening is a convergence of law and reputational management issues. So, previously, the contract said X, the judge said X, everyone thought the answer was X. In today's world, the contracts say X, the judge may say X, but the world believes it's X and Y, or even Y. And so because of that, there's been emerging a convergence of law and reputational issues where they're basically two sides of the same coin, and you have to be having both sides of that coin to have a fulsome protection. And this isn't just me saying it, but there's very high-profile examples. So the General Counsel of Twitter is now also their Director of Communications. The General Counsel of SAB Miller is also the Director of Communications. And in fact, FIFA has obviously been through a pretty tough time reputationally for the past few years, to say the least. This is an FT piece from about 3 months ago. FIFA is run by a law firm, Quinn Emanuel, who you may know of, a very famous US law firm, and a communications firm called Teneo. And the article says, you can't read the text, but the article says every decision coming out of FIFA is jointly made by the law firm and the communications firm. which exemplifies the very point that you have to be combining your reputational issues with your legal issues, and don't just think about what the underlying contract says. So here's a 5-step approach if your company is involved in litigation. I think first and foremost you should be speaking as general counsel, as legal counsel, to your communications reputational head, whoever that may be. Get them involved, present the case, these are the background facts, this is what's going on, how can we best position this publicly, externally and internally. And you develop together with your reputational person, and often your chief exec, and these reputational issues now are front and centre of a chief exec's sort of priorities, developing a robust point of view. And you have, obviously, in litigations that go on for many years, you'll have lots and lots of documents. Your robust point of view should be put on a one page. So when your chief exec who's your ultimate client really, is out in the public and cornered by a disgruntled employee or cornered by a digging journalist, they have at the top of their mind 3 or 4 points of view that they can quickly get across and present your case. So develop a robust point of view with the legal team and your communications team. And then step 2 is continuously educate your stakeholders. So you should be looking out and identifying who the key influencers are within your business, for your business, whether that be customers, whether that be politicians, whether that be regulators, and of course your own employees. And you should be continually communicating with those audiences and getting across your point of view. And then if the other side does employ media tactics, you should be what we call rapid rebuttal, immediately looking at what's been said in the media. If it is inaccurate, be ringing the media outlets themselves and saying, this is defamatory, this is inaccurate, please take that down, I'd like a correction, I'd like an apology. There's various things you can ask for, but be constantly monitoring what's been said in the media, and if the other side is perpetuating inaccuracies or untruths, they should be corrected immediately, because if they're not, that will slowly, that fact, or this fact, will become the truth. So be constantly armed to engage with the media outlets themselves. Point 4 is identify spokespeople. Often that will be your chief executive. Brief them, you're the lawyer, you know the legal facts. These are the legal facts. If you're, as I say, cornered by a disgruntled employee or whoever it may be, these are the 3 points you want to be getting across. And reiterate them, repeat. That's what politicians do, that's what Ed Miliband did. Deliberately, they repeat things 3 times, because a goldfish's attention is 7 seconds and a human's attention is 6 seconds these days. So if you don't repeat it, it doesn't cut through the noise. So identify your spokespeople. And in many cases, you will be the spokesperson. As a lawyer, you're more trusted in many cases than the chief executive. The chief executive is sort of establishment and often not trusted. He's sort of a sound piece for the company. Of course, he'll say X, Y, Z. You as the lawyer are the expert, slightly detached, third party, and more trusted in many cases. So it may not always be your executives that are your best spokespeople. If an incident happens on a steelworks on the plant, it may be the person on the ground who's closest to the facts and most believable. This is what's happened. Yes, there's an ongoing litigation now. We're doing everything we can to resolve this, etc. So identify spokespeople and train them. As the lawyer, you're closest to the legal facts. Make sure you're involved in those conversations. And step 5, finally, anticipate the legal timetable. So over the course of your litigation, there'll be various milestones where there'll be a preliminary hearing or whatever it may be. You'll be in court or at trial, and those moments in times may be used by your opposition to leverage and amplify their point of view. So look ahead at the however long the legal timetable is, and identify moments in time where you need to be prepared to put across your position. So finally, these are some of the companies that Elderman has worked with over the past year or so, where they faced fundamentally legal issues, but in fact they've been played out in the media. I won't go into, some of them are sensitive, but the point being that the legal position was quite strong in most of these cases, but the opposition was using the other battlegrounds to get across their point of view. Yeah, I won't go into detail into many of them. One in particular is a famous golf club in the UK, so it's called Wentworth Golf Club. it was taken over recently by a Chinese company, and the members didn't like what the Chinese company was doing in terms of its organisational structure. Legally, it was absolutely sound what they were doing, but the members who, many were retired and had lots of money and had the inclination, used all the other battlegrounds to perpetuate a sort of position that wasn't true. And it's a very good example of, obviously get your legal position straight first and foremost, but think about the other reputational issues that could come hand in hand with that. And as I said, Elderman, this is a sales plug, but we are everywhere, and if you're involved in litigation, the first and foremost thing you should be thinking is speak to my head of communications at the company. As a lawyer and a communicator, you need to be working together. If you don't have such a person, then look to external advisors, and they can provide you with counsel. But you have to have the two sides of the coin working in unison to best protect your position. Thank you very much.